You must be seeing the dome of the Capitol and the words legislators in session. The session started, and the legislators that we all work with have up until um, February 18 to be, they have the time to actually advance and or submit the bills that they want to go through the House committees and so forth for approval uh, in the state legislature. So they have up until the February 18th to do so. One important bit of news is that California Association of Realtors has filed an amicus or a friend of court brief with the United States Supreme Court. The case involves City of Los Angeles's moratorium extension. And this amicus brief was filed along with AGLA, Association of Apartment Building Owners of Greater Los Angeles. Now, this is the first time that a case like this has been filed with the Supreme Court. Now, there is no guarantee that that will be heard, but the court has signaled interesting stuff that they have turned around, for example, told the city of Los Angeles to provide information, a brief in response to the request. And we will see whether or not that's going to be done. But I just wanted to let you know about this thing and share with you with some of the reasons why this California Association of Realtors amicus brief was filed. One of the reasons was that, look, about 40% of the housing providers are mom and pop owners, and they may very easily go through the hardship that, even if not some more, than a tenant does. And just to provide relief month after month after month after month, it's not fair to the, especially to the mom and pop housing providers. The second one, of course, was that a lot of tenants may be abusing and hiding under the umbrella of these protections when they don't have to, because they do have the wherewithals to pay their rent and go forward. In fact, we'll visit that in the next segment and show you an example that was used at the by Catherine Barber, our supervisor, District 5, yesterday in the hearing about the extension of the moratorium in Los Angeles County. Of course, all of this comes under the Constitution, Article number 1, Section number 10, that says that no state shall pass any law impairing the obligation of contracts. Now, you don't take that literally because there are emergency cases and exceptions. However, a lot of deference has to be given to both sides, and it's the feeling of AGLA and California Association of Realtors that in this case, in case of Los Angeles, the city of Los Angeles, extending its moratorium, that deference was not given to especially mom and pop landlords. And of course, they are one of the arguments that CAR is using is comparing it to other businesses. In other words, you don't go to the grocery store and say, because I do not have a job due to COVID-19, I am not going to be paying you for the stuff that I'm going to be taking off your shelf. Or you don't go to a burger joint and have your food and enjoy your fries. I do it with no salt, and turn around and say, you know what? I'm not going to be able to pay you, and I'm protected under C-19 COVID protections or the moratorium extension, right? There is no moratorium in other businesses. We just get singled out time after time after time when an emergency of this nature, rightfully so, that happened. But we are at a point that the economy is opening, and we have to be cognizant of that fact. And of course, it basically this moratorium disallows evictions under Ellis Act, and that weakens the Ellis Act as we speak. So I thought it's important for you to know about this thing. This is where your RAF monies, by the way, or contributions, play a great role. Without your advocacy, we cannot, CAR cannot fight these issues that are absolutely bad for mom and pop clients, your clients, housing providers, and so forth. Now let's go on into providing you with some legislative updates on what CAR opposes and or actually supports. You have heard about Assembly Bill 854. This was put through by Assembly Member Lee from San Francisco, and it just passed its Housing Committee as well as the Appropriations Committee. So it is up for a vote on the Assembly floor. What is it? CAR opposes this, and it does because it weakens the Ellis Act. In a sense, it turns around and tells you, the four-unit owner, or your client that owns 7 or 8 units, that you cannot go out of the business and use the Ellis Act, and unless you've owned the property for at least 5 years, and you can only use it once, and then after that, it will take you 10 years to get out of the business of real estate. Again, it's an imposition that is unreasonable on this segment of providers to the economy of our region. I've shared with you the impact of realtors and their clients and so forth with our region in sessions past in hundreds of millions of dollars. So a little bit, the CAR will be opposing this, and I want to let you know about Ellis Act. This was sponsored by California Association of Realtors in 1985. It allows you to go out of business and give 60-day notices to all of the tenants, not just one. The tenant cannot be singled out, and reclaim your property. As much as the municipalities want you to stay in the business, Ellis Act allows you to do that for whatever reason it is, right? And this measure, AB 854, will curtail the protections that Ellis Act provides for housing providers. Next one is Assembly Bill 1486 by Assembly Member Wendy Carrillo. Why is this important? Because our own president, Eric Toro, is the key contact for Assembly Member Wendy Carrillo. And right now, the newly formed Assembly District of south of Glendale, which is, I believe, Assembly District 54, falls within the jurisdictions of Assembly Member Carrillo. So it's important for you to know that she suggested and or put a bill into the assembly, into the legislative process, which CAR supports it. That bill has to do with CEQA and streamlining of CEQA for housing reform. In other words, the California Environmental Quality Act should not be used in a manner that is going to stop production of housing, which is the #1 critical issue that the state has, at least the polls show that, forever has been facing. So CAR actually supports Wendy Carrillo's bill, Assembly Bill 1486. Another win for CAR was Senate Bill number 12. Senate Bill number 12 actually deals with very high fire hazard zone development standards. And this stayed in the committee, did not clear the committee, and that's a win for California Association of Realtors, because in a nutshell, it was saying that unless a city like City of Glendale, which about one third or half of its properties are on hillsides, does something major citywide in order to address wildfires and so forth, you're not allowed to develop on in those areas. Now let's go on to what you've been hearing a lot, which is news about the Appraisal Foundation and the issues that appraisers or some appraisers have created that really is a slap in the face of fair housing laws. You are going to be hearing a lot of news in this space. A report was prepared by the Federal Financial Institution Examination, and it was prepared for National Fair Housing Alliance. And that report was done because, just to give you an example, in Marin County, one of the examples of this approach to appraisal, which is detrimental to fair housing, a black family, an African American family, had to whitewash their home for a second appraisal. And the moment that they did that, all of a sudden their appraisal value of the home went up by $500,000. Now, this is not a coincidence, right? And we see examples of this time after time after time. Of course, the Appraisal Foundation has vowed to fight this stuff and educate its members a whole lot more. And here is why it's important. Aside from the moral imperative, the moral issue at hand, there is a difference in appraised values between white neighborhoods as opposed to black neighborhoods to the tune of $156 billion. And if we do believe, as realtors, which we should and we do, that this middle, basically, this transfer of wealth is of utmost importance. And one of the easiest ways of our families growing and being participants in the economy, if we do believe in that transfer of wealth, we have to believe that exercises and stuff like this has to stop. So tune in. You will be hearing a whole lot more about this appraisal issues that we've been facing. I like to talk a little bit about solar. The picture shows that you collect the solar arrays and you store it partly in your batteries, and through your inverters and meters, sell the excess solar power that you need. You send it back to the grid. Why am I bringing this back is because, according to New York Times, 10% of the California generated electricity is through solar rooftops. And we have mandates that by 2035, 2045, we need to go all electrical. We're not going to be able to do that without what is known as the solar rooftops or distributed electricity. The reason we can't is very simple. We have constraints on our grids. I'll talk a little bit about that, and we will explain it to you what we mean by that. CPUC, by the way, this fight about generating solar via your rooftop or distributed way versus solar farms is really backed by labor unions as well as utilities. It's all about the money. Who's going to make the money? Now, CPUC, that stands for California Public Utilities Commission, came up with what they call net energy metering, or NEM number 3.0. What it was suggesting was basically that the 1.3 million, we know we have 1.3 million solar users right now that have got solar rooftops, right? What CPUC was suggesting was cutting the incentives for solar installations in future by about 80% and adding what they call a tariff or a monthly fee to the existing users' accounts. The fear is and was that this will disincentivize the use of solar in the future. Many of your clients may have it on their rooftops. Many of them may have written or participated in a contract that they pay over time. So this thing has got some ramifications. Now, CAR opposes the CPUC's proposal, basically, again, based on the standard of the solar energy industry, that this is unfair to the workers of the solar energy and unfair to the customers of the solar energy, the rooftop solar energies. Now, this was a huge deal in our last business meeting, and in fact, in our caucus, Region 13. As you know, Arcadia, Pasadena, Glendale are part of Region 13, and there was a lot of discussion about it. At the end of the day, again, CAR decided to oppose it. Fortunately, um, I am able to give you a local perspective when I referred to constraints on the grid. You all have heard about the Shul Canyon biogas, a huge brouhaha uh, basically developed. A lot of people from inside Glendale and outside Glendale did not want to have the biogas be put on the dump at Shul Canyon. What the biogas was supposed to do and will do is to take the methane gas, right, and turn it into electrical power. By some estimates, it will fuel somewhere close to about maybe 10 to 20,000 homes in city of Glendale, and it is considered green energy or green approach to producing energy by AQMD. One of the reasons why city of Glendale had to go through putting a biogas or internal combustible engines, small ones at that, in Shoal Canyon, is because City of Los Angeles refuses to provide additional electricity through the grid to City of Glendale. If Los Angeles was able and would agree to provide that electrical energy, Glendale would not have had to put the biogas on Shoal Canyon. So that's the reason. Again, there is going to be a lot of talk about this in the future and in this space, and we will keep you updated as we go along. CPUC, as we speak, has tabled the measure. The governor has chimed in, has told them, look, changes have to be made, no questions about it. But in many words, unspoken words, has said he does not like the way in which this measure was proposed. Okay, so what's going on in our neck of the woods in Glendale, especially in the area of tenant and landlord, and basically in that arena, as far as moratoriums and so forth. I want to update you. Yesterday at 3:30, the Board of Supervisors decided to extend the moratorium, the rent moratorium, up until, I believe, about a year from today. So this thing will go through 2023. That vote was 4-1. Our District 5 supervisor, Catherine Borger, was the only person that voted against it, and she did so because she was unwavering on her principles, that you're hurting mom and pop landlords, that tenants are getting a lot of relief. Remember, we talked about housingiskey.com and so forth, and that the economy is reopening. We are going to be hosting the Super Bowl pretty soon. And for us to be using a draconian measures of extending the moratorium is uncalled for. Pardon me. So what? What does that have to do with City of Glendale? Well, we know that Montrose and La Crescenta, part of Glendale, but it's part of unincorporated LA County, which means that this moratorium would affect the housing providers in La Crescenta and parts of Montrose that falls under the unincorporated county jurisdiction. So that's a big deal. How would it affect City of Glendale proper? Well, City of Glendale is a charter city. It is governed by what is known as home rule. In other words, from what I'm hearing, this will not have an effect or should not have an effect on any charter city, such as Pasadena, such as Burbank, such as Glendale. Remember when we tried so hard and you were so great in responding about redistricting, keeping Burbank, Glendale, Pasadena under District 5? This is one of the outcomes that our supervisor voted against this measure, rightfully so, and the other four supervisors from different districts voted for the measure. So as far as Glendale, Pasadena, and Burbank were concerned, our supervisor, Catherine Barger, did the right thing, and we appreciate what she did for us. And it is important that you understand that right after that motion was approved, Supervisor Barger introduced a new motion that no rent, no property tax, at least a feasibility study on that, right? That the CEO of the county to go out and find out if it is possible or not. So in other words, as a landlord, if you're not collecting any rent, you have no obligations. Your property taxes should be forgiven as well. That was a countermeasure. Interestingly, all five supervisors approved it. And this was a bold motion by Catherine Barger. And again, we appreciate for what she has done. Please do send her a note thanking her for her stance, for her position, because I think it is important that she hears that we appreciate the position she took on this thing, which, by the way, was the correct position. All right. What else is happening in City of Glendale? City of Glendale approved and started the ad hoc landlord and or housing provider and tenant committee. Understand, this is not a commission yet. It's an ad hoc committee. It is designed to operate for 12 months to see if it is effective and to see if it's not, how they can change it and then turn it into a commission. This committee has got 3 tenant members that were elected by the council, 3 housing providers, and 1 moderator. I have the list of the people. Their resumes are online. If any one of you want a little bit more color and detail in it, you can reach out to me. The hope is that a lot of the issues that tenants are concerned about and or housing providers are concerned about will be discussed and handled and agreed upon in this ad hoc committee. So that's the other news. Now, we've talked about housingiskey.com, and we have shared with you the amount of relief that is being provided to California through the federal assistance, about $4.5 billion, and I believe another $1.5 billion or so from state of California, a total of about $7 billion for close to $7 billion for this rent relief stuff that has been happening since March of 2020. Don't forget, we are in the 2nd year of the moratorium right now, right? According to housing.com, in City of Glendale, 6,025 people have applied to receive relief. Out of that amounts to about $123 million in requested funds. Only about 38 million has been dispersed in City of Glendale. We're talking about Glendale only right now, right? And that is approximately about 30%. So 70% of the tenants or the housing providers that have requested funds are yet to receive those funds. And the average grant per tenant was approximately $13,800. In months ago, actually, we talked about this issue, that it is important that these relief funds get funneled quickly to the tenants and their housing providers. Because if they don't, there would be no light, at the end of the tunnel. And in fact, we used the picture of a train in the tunnel. This is one of the reasons, by the way, that the other 4 supervisors articulated that is why they are going to extend the moratorium in LA County. Because just like Glendale, Los Angeles County has only received about 30 or 40%, 30 or so percent of the funds. By the way, that amounts to close to about 500 to 900 million dollars, but it's still not enough. So the next thing that I want to talk to you about is unemployment on the local level in our Tri-City areas. If you remember, in March of 2020, the unemployment shot up to close to about 20%. And of course, today it has changed. It's not that. City of Glendale has made a lot of strides. Our unemployment rate is about 7% versus Burbank, that is 8.2%. Pasadena, that is about 5.8%, and Montrose La Crescenta, believe it or not, at 5.7%. Now let's compare this to state and basically a county, state, and United States. The county's unemployment is about 7.1%, albeit there's some data that shows it's about 8%. California's unemployment rate is about 6.9%. So you can see that we are toggling in the same area, basically within the same numbers or percentage rate of the state unemployment. I'm talking about Glendale and I'm talking about Burbank. Pasadena and Montrose are doing better than the state of California. But when we go to United States and we compare ourselves to United States at 3.9%, you can say that we still have quite a road to hoe. And of course, we are going towards that. We will get that. There is no questions about that in my mind. But I wanted to share with you what the current unemployment rate is in City of Glendale. Next, we've talked about Glendale, Pasadena, and Burbank, and median values of the homes and condominiums and so forth. And today it's around about $1 million plus. And we will be updating you on this stuff on a quarterly basis. Then I want to share with you with the list of the cities that have been assessed by the tax assessor office. City of Glendale is number 6 highest valued assessed city in the county. Pasadena, of course, is number 7, and we are very close to about $36 billion of assessed value. And Burbank is number 9 at around $26 billion of assessed value. In comparison to last year, that's an increase of 3% for Glendale, 3.7% for Pasadena, and about 2% for City of Burbank. This was on the lighter side of the information that I wanted to provide for you. But again, it's a testimony that these 3 cities have always been in the top 10, and that shows that a lot of people do want to live in City of Glendale, and that's one of the reasons why your assessed values go up, right? When people purchase properties, and the increase and so forth reflects in the assessed values. With that, President Eric Toro, I appreciate the time. Unless there are any questions on the part of you and our members, I'll be happy to.
We actually do have a question, but before I go there, first of all, thank you very much, Greg. Your information is always very valuable. Robert has put in the chat the contact information for Catherine Barber so that we can thank her. So from Ira Bland, we have a question. Does the rent moratorium extend to commercial? Also, if you have contractual agreements in the lease, whether commercial or residential, can you still raise the rent per contract?
Yeah. Very, very, very good question. The moratorium, the LA County moratorium that starts in February 1st, includes commercial, but not on the rent. Only on the harassment issues and intimidation, which apparently by some landlords to the commercial tenants and so forth. So the commercial rent has to be paid. There is no freeze. There is no moratorium on it. As far as the increases are concerned, again, that's depending again which city, which jurisdiction, and so forth. For example, in the City of Glendale, you can increase. You have a cap of 7%. Now, You can go above 7%, but then you have to pay a relocation fee to the tenant based on a formula that is derived from the years and or the months that they've been a tenant of that specific building.
Carmen has a question for you.
Sure.
Carmen Aram.
Good morning, Greg. Thank you so much for all that good information. I need some clarification about this, the extension of the moratorium. I understand it was approved for LA County starting February 1st, but then you mentioned what this means for Glendale, and specifically you focused on the unincorporated parts. So does that mean that for the city of Glendale, for the properties located in the city of Glendale being a charter city, this moratorium does not apply?
You're absolutely correct, and very, very good observation. Depends on where you sit, right? If you ask a county attorney, is going to say, no, it applies, it's countywide. Through the information that I have from the city of Glendale, it does not apply to the city of Glendale, but it still remains to be seen. The fact remains that the city of Glendale is a charter city. Under the Constitution, no other city or jurisdiction, unless it's an emergency, by the way, by the state, not the county, can impose its laws or ordinances on a charter city.
So for non-payment of rent in the city of Glendale, you can evict a tenant.
Well, you have, again, I'm not going to generalize the statement that you put in because it all depends. It all depends because has for example, the notice of stress under COVID-19 been filed? Has the tenant and or the housing provider provided applications to housingisKey.com? Because if you haven't, you're not going to be able to do it. But if you have, and the tenant does not pay, then you got 20 days to go to the court and do that. Again, I'm not an attorney, don't pretend to be one. This is why I'm very, very hesitant to make comments about other than the policy, right? Specific cases are very, very difficult for me to actually hone into.
And where can we find the names of the people who've been selected on the tenant landlord committee?
It is already online, and I will tell you from the housing provider side, Razmik Grigorian was appointed. There is another name, and the mediator is an attorney, a Hyrabedian. But on the tenant side, I do not remember the names. But overall, when I looked at the composition or the makeup, and I looked at the resumes of each person, I think it's a balanced committee right